Mr. President of today's proceedings, Mr. Chairman of the Madras Bar Association, Mr. Raja, trustees of the Pankawala Foundation, I'm absolutely delighted to be with you all today, and everyone else I address very warmly as colleagues, colleagues at law and colleagues too, with, I hope, some appreciation of the history that's just been described. I hadn't realised quite how important the Madras High Court and the Madras Bar Association was in the history of India. And I'm thoroughly delighted to be here on the 150th anniversary, I suppose, and to wish happy birthday to the association and to the court. I was delighted to hear Mr. Raja, and very interested to hear of the extraordinary history that you've just recounted of the Indian legal profession, of this court and the Bar Association. And what came through to me particularly was the historic firsts in upholding the excellence of the Indian legal profession, an acting Chief Justice, I think you said an additional Advocate General at a very early stage. This is extraordinary and very, very much to be admired. So thank you very much indeed for the warmth of your welcome. I'm glad that the warmth inside this hall is not quite as it is outside. I'm always delighted to be in India, but the temperature sometimes discomforts me a little bit. I'm also very delighted to be here because I do travel a great deal and have both in my professional life and also in my political life. India stands as a beacon of, despite the size of the country and the challenges which face the country, of a beacon recognizing democracy and the rule of law, and nowhere more than in the courts and through the judges and the lawyers and advocates of India. And I'm very happy to salute all of that this evening and be very pleased to be welcomed by you in this very warm way. Let me then turn to the subject. We had a little bit of discussion, Mr. Raja, at least through colleagues, about what I should speak about this evening. It was decided that the art of advocacy might be an appropriate subject. I approach it with a little trepidation, because although I have a little experience, I'm very conscious that in this hall are those with enormous experience in advocacy, so I will be offering something of a personal approach to this, and I hope it will be of some use, particularly perhaps to the younger members, the more junior members of the profession who are here this evening. I want to say something, therefore, about that. I also want to say something which I hope will be thought to be appropriate, particularly because of the joint sponsorship of this evening by the Pankawala Foundation, about arbitration, which is, in a sense, the newer side for advocacy and for lawyers. And it's an area in which I have some particular experience. And then I may conclude with one or two words, really, just about the global nature of the legal profession and perhaps what that may mean a little bit for India and its great advocates. But before looking at the future, one needs to go back, because advocacy and the art of advocacy goes back a long way. One can probably trace it particularly to the study of rhetoric in the Greek colony of Syracuse in the 5th century before the Common Era. That's where advocacy really started in a scientific way, and it spread from there to Athens, the great city-state, where it became a highly tuned art. The ability to sway the assembly, which theoretically the assembly in Athens was all of the male citizens. I have to underline the word male because there wasn't that degree of enlightenment at that stage, but still, so far as democracy was concerned, Athenian democracy was, of course, a trailblazer. And all of the assembly listened to orations. The great men made speeches to them. They made speeches to juries. They were really the first professional advocates. And it became the path to power. And actually, if one looks around the world today, one still finds many lawyers and advocates who found their path to power through the law. I served a Prime Minister, Tony Blair, who, though he tried often to forget it, was himself a barrister. From Greece, advocacy spread to the Romans. Two of the greatest Roman orators were Mark Antony, whose Shakespeare at least had declaimed an extraordinary speech on the death of Caesar, and Cicero, one of the greatest advocates of all times. It was said that Cicero practiced his advocacy on the seashore with pebbles in his mouth so as to make his voice clear and carry across the tumult of the waves. With modern microphones, that's probably not a necessary technique to follow today. But Cicero wrote an extraordinary work called De Oratore, which described the science of rhetoric and advocacy. There are some who thought this went too far. For example, Plato, the great philosopher, became disenchanted with democracy, particularly because he was concerned that it was advocacy and rhetoric and sophistry which had led to the conviction and execution of the great philosopher Socrates. So there are two sides to this coin. The modern world of advocacy is different, but nowhere is it more important than in the common law countries. In, of course, my country, but here in India, in Australia, in the United States, and in many other countries where the oral tradition of courts and of justice has continued. I have some experience of the civil system. In fact, I'm actually a member of the Paris Bar. I've never actually dared practice in a French court. I got through by some extraordinary sleight of hand. I know not a lot of French law, and indeed when I went to swear my allegiance in some way to be admitted as a member of the French Bar, I was asked by the young lawyers there which of two colleges I'd studied at. There are only two, and of course I attended neither of them. But if you find yourself with a driving prosecution in a small town in France, I might be able to help. I wouldn't put my skills in the French court any higher than that. The styles of advocacy that we have throughout the world, I think, are now different and changed. And I'm going to focus on the advocacy that I know about. The United States has developed a much more flowery, they might say eloquent, approach to advocacy, substantially because they still spend far more time before juries than we do. And that leads, and it'll be one of my early points, about tailoring your advocacy to your tribunal and knowing your tribunal. They have a very different approach because they are, most of the time, even in civil cases, addressing 12 non-legally qualified people about the issues. And that does lead to a different approach. There's a saying from the state of Kentucky that says, the motto for lawyers, if the law is on your side, argue the law. If the facts are on your side, argue the facts. And if neither are on your side, just shout. My own background, you've heard a little about it. I'm very grateful to Mr. Raja for describing it. I will have been practicing as a lawyer for 40 years next April. It's the first time I spoke as it were, use my advocacy skills in anger. I was going to say the first time I was paid for it. I'm not actually sure I was paid for my first case, but it's probably too late to ask for payment now. I suspect I'll be told the statute of limitations ran a very long time ago. And over the years since then, I've had the great fortune to be an advocate in many courts and in many causes. I've appeared many times in the British House of Lords, in the Court of Appeal, in every court indeed, in England and Wales and in Northern Ireland, never in Scotland. The Scots remain extremely proprietorial about their courts. You have to be a Scots advocate to appear there. So one day, my ambition may be to appear in a Scots court, but they won't have an Englishman there. In courts overseas, the European Court of Justice, very different court from the British courts. The first time I appeared in the European Court of Justice, which sits in Luxembourg, was shortly after the United Kingdom had joined the European, was then the European Communities. And we found ourselves, I was being led by a very senior QC, found ourselves in this courtroom with a very significant number of judges, with headphones on, listening to our speech. And what surprised me was that they didn't say a word. I was used to a court that was interventionist from the very first go, often. You'll be very familiar with this in courts here. They didn't say a word. Finally, after 35 minutes, the president of the court opened his mouth. What extraordinary, insightful question is he going to ask? What he said was this: Mr. Dane, that was the name of my leading counsel, you said you'd be 30 minutes. You've been 35 already. Different style of advocacy, and I'll say something about that. I've appeared in courts, common law courts in many parts of the world, in Belize, in St. Kitts and Nevis, in the Cayman Islands, in the Bahamas, in Singapore, in Hong Kong. I even appeared in, which is not of course a common law court, in Bulgaria, which is an extraordinary experience, and quite why they made me a member of the Bulgarian bar to appear in this case is a little bit beyond me. And I'm a member of the Bar of New South Wales as well, where of course the Australians believe they're the only place which still practices the proper common law. They think England has gone to the dogs since we joined the Europeans. And I've also the experience of practicing advocacy in the political sphere. I remain a member of the House of Lords in its political, in its legislative capacity, the upper house. I've been a member, as you've heard, since 1999. When I was Attorney General, I used to address the House frequently on legislative proposals, and I still participate on matters where I have an interest. I'm no longer simply representing the government's point of view. Indeed, quite a lot of the time I say things the government would rather I didn't do. Very simple, if they don't want me there, they can just instruct me to go in court somewhere else. I wouldn't mind that particularly. So let me, from what I've learned, really try and set forward perhaps just a number of rules which to me are the rules which relate to the art of advocacy. I'm going to save till the last the three which I think are the most important. You may disagree on the significance to be attached to them. To me, they're the most important. But the very first is that, and my first rule, is advocacy is about communication. It's not about showmanship. There's great stories of showman advocates, F. Lee Bailey, Marshall Hall, Carson, great names, who practiced their skills, particularly before juries, in a way which today would be regarded, I think, as showmanship. But for me, the key is that one is trying to communicate something. Communicate to particularly the judge, perhaps to a jury if a jury is there, sometimes a little bit to the public, if it's the sort of case where you actually want to be saying something publicly. But essentially, advocacy is about communication. And I think, if I may say to the younger advocates, the thing you have to keep in mind, it is about communication. If at the end of your speaking, the person you're speaking to doesn't actually understand what you've been saying, then you have failed. Unless, and I don't recommend this, but some people do, what you're actually trying to do is to win the case by confusing the judge. What you have to do, therefore, is to understand your case and communicate that to the tribunal. And there's no point demonstrating that in a showy way. There's no point demonstrating it in a way which is appearing superior, because you're actually trying to persuade. The great advocate who went on to be Lord Chancellor, F.E. Smith, who went on to be Lord Birkenhead, was a tremendously successful advocate, but I don't think it was because of his tact. On one occasion, he was addressing a judge, and after he'd been speaking for some time, the judge said, "You know, Mr. Smith, I've been listening to you for half an hour, and I am none the wiser." The judge, F.E. Smith, said, "No, my lord, but you're much better informed." That's not the way to impress your court. So my second rule is you need to know your audience, and you need to shape your advocacy to your audience. Now, we can all categorize pieces of advocacy in different ways. Who are you addressing? For me, there are three particularly broad categories. First instance advocacy to a judge, appellate advocacy, and, if one's involved in it, advocacy to a jury. They're all very, very different. The same basic requirement to communicate is there, but in a different way. With a first instance judge, you're trying to explain what the case is about. It's your first opportunity to demonstrate why your client is right and the other side is wrong. And there has to be a level of intellectual quality to what you're saying, because you're addressing a qualified, professional man or woman who understands the system. If you're addressing a jury, on the other hand, then you have a different approach. And I've addressed juries both as prosecutor and as defendant, because there you are dealing with a group of people who don't have legal qualifications, but don't underestimate their intelligence or their insight. Don't play them for fools. That's a big mistake. So you have to both teach them something about the law to understand your case, but without doing it in a way which makes you look as if you're being superior and above them. And then appellate advocacy. That's one of the greatest skills, because it's one of the most difficult things to achieve. There you are dealing with more senior judges who've heard it all before. They will often know the answer, they believe, before they come into court. And you can find, I've found it many times, you go into court, and before you've even opened your notebook, one of the judges has said, "Your problem, Lord Goldsmith, is..." Now, he may have hit upon something that you thought was a problem. It's equally likely it's something you didn't think was a problem. And you have to deal with that immediately, respond to that, and get back onto the track that you have started with. It's even worse if you are in the next level of appellate courts, used to be the House of Lords, now the Supreme Court, where you have more judges. If you have 5 judges, they hunt in packs. There you are, dealing with one in the middle or on the outside. You think you're winning the argument, you're responding to what he's saying, and then one comes in from the flank and attacks you from the side with some entirely different point. One of the most difficult things, our House of Lords, now Supreme Court, normally sits in substantive cases in panels of 5, which is bad enough. On some occasions, increasingly now, when I was Attorney General, I had 2 occasions where I had 9 of them. Terrible. Terrible. And you think you're there, And then another point comes. There was one lovely judge, actually, who was trying to work something out on his calculator. I never really understood what it was. But every few minutes, when I'd moved on, he would say, Lord Goldsmith, just come back to this. And he'd be doing something on his calculator and put that to me. You've got to keep your train of thought throughout that. So you need to know your tribunal. You need to know your judges, if you can. This is why some advocates of experience are particularly fashionable, because they understand their judges, they know their judges, they know what's going to appeal to them and what won't. It's not the same for every court. So do your research. If you're doing a case, try to understand, try to find out in advance who your judges are, and try to understand the sort of things that to them are important. The great legal writer, Glanville Williams, was a great writer, he was a great teacher, he was a rotten advocate. And he never really got the hang of advocacy. In his early days, he said on one occasion, following my adage, know your tribunal, he said to a judge, he said, I've got 3 points to make. One of them you'll understand. The second, if you try very hard, you may understand. The third one is very difficult. I'm going to save that for the Court of Appeal. Not great tactic. He sort of got the idea, think about your tribunal, but he shouldn't actually have told the judge that that's what he was doing. On the other hand, there are cases where you should leave certain points to a later stage. For my third rule, I want to turn to the art of cross-examination, which is a particularly common law art. It doesn't really happen very much in the civil law system, in continental Europe, for example, because they don't have the same adversarial system. They have an inquisitorial system, and the inquisitorial system means that the judge is asking the questions, not the advocate. So the skill of cross-examination is lost to them. Key points about cross-examination are the same. You have to understand what you are trying to communicate, but you have to understand that cross-examination, as one judge said to me when I was quite junior, is not the same as examining crossly. It's not about having a harsh voice and being strident. You may need to be firm, but actually you want to coax an answer out of a witness. The most difficult witness to cross-examine is the honest witness. There you have to get them on your side, and if you start to be aggressive with them, the worst will happen. They will start to give you